Another estate planning mistake that people make is they don't get a full plan. They get the will and the trust, which is fine. Everybody needs the will and the trust. But they don't get the rest of it. That's only half of it. I talk about a foundation in my book. There's a certain foundation that everybody needs. And pretty much any family needs this foundation. The will and the trust are part of the foundation. But if you're just getting those, you only got half of what you need. So you go to the lawyer, he only gives you half of it. Well, you come back, you got to get more. That's another chart. You go to the internet, you only get one piece, one piece, one piece, one piece. No, you got to get the whole foundation all at once. And the mistake people make is they don't even know what the foundation is, or if they do know what it is, they don't get it because the lawyer only gives them the package deal, or the internet only gives them the package deal. You need the will and the trust, and there are two more things at least that you need, minimum. One is a durable power of attorney. We couldn't have it until the early 80s. I remember my uncle, he went to the Korean War, and I was just a little teeny kid when this happened. And the war was over. I'm not that old, all right? But at any rate, he goes and he's just bought a new pink Thunderbird. I remember it. It was a convertible. He took me for a ride in it. And there's no use hanging this car around for the next 2-3 years while he's in Korea. So he gave Grandpa a power of attorney, and I remember watching him write out this piece of paper so that Grandpa could sign the title and sell the car. Well, Grandpa did that, actually. The problem with that is, as soon as the principal, the guy who made out the piece of paper, gives the agent, the person who has the authority to act on the principal's behalf, as soon as the principal is incompetent in any way, they become, have an accident, they can't function for themselves, general power of attorney, which is what the uncle gave Grandpa, that one kicks out. It's gone. It's invalid. Well, in the 70s, we woke up and said, well, duh, this is dumb. The time we need the power of attorney is when the guy is incompetent and he can't act for himself. So we passed new laws, which said that you could make out what's called a durable power of attorney. The power of attorney endures through your incompetency. Now, it's got to have special language in it. The language in the general power that my uncle gave Grandpa, that wouldn't work. So it's got to be written differently than the general power of attorney. But you need the power of attorney. The fact of the matter is, you're like 6 or 7 times more likely to be incompetent and not be able to manage your own business affairs next week than you are to be dead. So the power of attorney becomes a very critical part of this whole foundation, this estate plan that I teach about in the book. My wife's a lawyer also. My wife and I both practice law. In fact, we're both counselors to the Supreme Court of the United States. So we know what we're talking about here. We've done it once or twice. Anyway, she has this case a number of years ago, and what happened is the dad had the heart attack, failed, and was on life support. The family, they all wanted together. They had to bring the kids from the East Coast and everything else. Dad's brain dead. It takes almost a week to get this family together so that they could unplug the plug and let Dad die. Well, they all get together, they're around the bed, they unplug the plug, nothing happens. Dad's still alive. Dad actually lived for another 5 years. Total vegetative state. He's got to be turned every 2 or 3 hours. I mean, it's a nightmare. Actually, his daughter was a nurse. She gave up her nursing. She did nothing more than full-time take care of Dad. Well, Dad's got property. We got to sell the property. How do you sell a property? Well, you get somebody named as guardian for Dad. Either that or you have the durable power of attorney, which allows somebody to instantly stand in, take over, take charge, do whatever they have to on behalf of Dad when he has his problem. Dad didn't have a power of attorney. Well, to get somebody named as guardian, the judge has got to see this guy. Yep, he's incompetent. Got to take him to court. So the only way you get him to court is you hire an ambulance. My wife hired the ambulance, got the first one on the docket that day, so that they could wheel the guy in, get the judge to look at him, wheel him back out. They get to court. Judge has car problems. He doesn't come in that day. They had to do this twice. This whole process could be just totally alleviated with the durable power of attorney. And you can have lots of different options in the durable power of attorney. I go through those in the book for you so that you're going to know what you can do, what you can't do. So you need a durable power of attorney and you need a living will. That's the directive to the medical profession. What do you do with me when I'm critically ill? Plug me in, unplug me, let me die, what happens? By the way, are there only old people in rest homes? I don't think so. This foundation, it comes into play for every one of you. The question is, what have you done to prepare the foundation when you actually need it? In the book, I go through my story. There was a period in my life, I spent 5 months in intensive care. It wasn't a question of if I die, it was only a question of when I die. On at least 2 occasions, I'm in intensive care, I'm dying. They call my wife to the hospital. Middle of the night. They don't bring her to my room. They take her to the administrator's office. And they sit her down and they say, okay, this is the situation. Do we give up and let him die, or do we keep going? My wife was alone when she made those decisions. We've never talked about that. We were only 27 years old. We had 3 small children. She sat in those offices and made those decisions. By the way, I think she made the right decisions, okay? But actually, since the Karen Quinlan case, Supreme Court of the United States says you got to have the written, living will. So I go in the book, I explain exactly what the living will is, very different than a testamentary will. I explain what it is, what you can do with it, what you can't do with it, and you need to know. Discuss this with your mom and dad. Let them read that chapter of the book. That way it's not you telling them, it's somebody else telling them. I explain why you have to do it, what happens. So get the pieces of paper, know what you can do, what you can't do, how you write the pieces of paper. The mistake that people make is they think the will and the trust is enough. That's a setup by the legal system. You need the full foundation because there are a lot of things that in many cases are legally a lot worse than somebody dying. Don't make the mistake.